Thank you for that introduction. I'm going to start off on this wider topic by giving you a more general introduction. So I will not focus necessarily on the jurisdictions that are more experimental or that may be leading into the future, but I will try and give you an overall idea of what I think may be some of the obstacles to developing longevity biotechnology, how to deal in general with those obstacles, and what is the role of law in that context. It is, for perfectly understandable reasons, only too easy to not believe that law will be crucial, law and regulation generally will be crucial in solving aging and resolving problems that longevity biotechnology might have. But I hope to show you that, in fact, it can play a substantial and, in some respects, perhaps even very significant role. So very few, it would be unnatural if I didn't have any disclaimers, given my legal background. This is my personal opinion, as opposed to the opinion of any organization or profession that I'm affiliated with. I will try, as I said, to be jurisdiction agnostic, and also, as warned, I will try and give you an overall idea of several ways in which law might play a role. Also, it might, at certain points, become, I wouldn't wish to use too strong a word, but somewhat emotional, as you would, again, expect from a legal presentation. Hopefully not too emotional. So I wanted to start off by telling you what I think is particular or special about longevity biotech. And it seems to me that it is defined by the following several points. Firstly, the total addressable market is potentially very large, but it is a very potential market. I have tried to put together some data I came across, both in relation to the metric of willingness to pay and the well-known article by Andrew Scott and colleagues in 2021 that was trying to measure what that might mean and arrived at $38 trillion of willingness to pay. That, of course, doesn't translate necessarily in marketability per se, but it still gives an indication of a very large market. And a more recent assessment, which has suggested that perhaps by comparison to GLP-1 receptor agonists, which are such blockbuster drugs, the first drug in aging will be an even bigger blockbuster. Secondly, however, in addition to that, there is, of course, considerable risk associated with longevity biotech. And that's the background risk that comes with a investment or any form of investment in biotechnology. These investments have led to a slightly lower return on investment measured by IRR, it seems, again, based on some data I was able to find over time. Notably, not too low, not too big a difference from other types of tech investment, but still perhaps a riskier, so far not as well returning investment. Then, of course, there are the biological aspects. And these are there's set to be some degree of complexity and some profound difficulty that we will face and that will be resolvable, but is special. So summarizing, there will be a considerable amount of regulatory, technological risks associated, but on the other hand, a prospect of a very large market and a prospect also of perhaps resolving other conditions and other diseases, spillover effects from this type of research. So you might wonder, as mentioned, how would law be at all relevant. The instrumentarium of law revolves around things such as the English judicial and barrister professions use wigs made of horsehair. Those have been tools of the trade for some time. How can these tools be adapted to a modern environment? And I think the answer broadly lies in saying that law has two aspects, the law that is now and the law that can be. And both are relevant for present purposes. We need to work with the law that is now, but we need to, I think, as a field, envision what is the kind of law that there can be. And I think it will pay to have a good understanding of the detail of both regulatory and legal nuance, such as to be prepared to alter that in the right direction and to predict its future direction as well. Speaking of law as a means of effecting policy change, this, of course, can be done through changes at the level of primary legislation, at the level of secondary legislation, by means of effectively piggybacking on other pieces of legislation that have nothing to do with what you want to change, by means of affecting international agreements. One interesting example, for instance, might be, in addition to standardization, might be the so-called non-tariff barriers to trade. At the moment, of course, there are no special provisions internationally, with some exceptions. There is a very specific agreement as to pharmaceuticals that is very ancient within the framework of the General Agreement on Tariffs and Trade. But more may be done in this field, for example, and also by seeking to affect international self-regulation. And as I mentioned earlier, I am trying to be jurisdiction agnostic, so the changes that can be effected through in policy through legislation should be workable irrespective of the mode of governance in the given constitutional system, so irrespective of whether we're talking about a classical democracy or a different system of governance. And then again, briefly, what may be on the shopping list of a longevity biotechnologist or an advocate for it. It will be things like resources, and these could be various, the literal cash, but also, as I will mention shortly, perhaps how to encourage or achieve better signaling for the available market signal or political signal that there is demand for staying alive in a healthy state longer, which currently is not getting through to politicians, it seems. Also, of course, creating more talent or encouraging more talent. So these are all desiderata for longevity biotech. On the funding side, you have heard already over the last few days about various modalities, and you'll hear shortly again about some ways in which these can be achieved in specific contexts. I have listed on this slide some, but I will not detain you with them. However, I wanted to briefly stop at one particular idea which has been bandied around, which is whether it is worth setting a target for spending, so for example, 1% of GDP. My initial research suggests that that will be very much worthwhile, but maybe the reasons will need to be, and mechanics of that will need to be explored. And there is a precedent, and the precedent is in the context of development assistance, official development assistance internationally, which is given to least developed countries and middle-income countries, except for those in the EU or which have been promised candidate status to the EU. There is a history to that I think is instructive. Such targets, of course, can work in other contexts too. So, for example, NATO has a soft political target for spending 2% of each NATO member state's GDP on defense. And that is something that, of course, President Trump was using as a means of bashing his allies politically several years ago. And now that target has been met because of events that superseded. So looking at how, in the context of development assistance, this target has functioned. It was a target set of 0.7% of gross national income by a United Nations resolution 2626 in 1970. And the way it was phrased was not particularly helpful. It was said that member states of the UN and, that should aim to the most developed economies, and it didn't specify which are the most developed economies, should exercise best efforts. So that was a best efforts clause. In the case of the United Kingdom, however, that country decided to legislate. And it did so during the coalition government of 2010, but with bipartisan support. So in 2015, legislation was passed that set that target, and as a means of enforcement said that if you don't meet the target, then you need to lay a report before Parliament to explain what's happened and to explain how you will propose to meet it next time around. Well, then of course there was the fog of COVID, and in November 2020, the then government announced that it was planning to actually not meet the target for the year after. And that caused, though, substantial distress politically and substantial uproar. And it was debated whether the government could just decide in advance not to meet that target, or whether it had to pass legislation to amend the target, because the government was now saying it was going to meet a 0.5% target. I think the lesson here is that such targets do have some sticking power. They can be used for political control, and they are therefore potentially worthwhile. I will need to perhaps skip some of the detail that I had ambitiously provided for in the slides, it is, though, a list of, again, desiderata on the what I've called the infrastructure side of longevity biotech, but that, I think, can be taken broadly to include things like the generation of, for example, PhD talent, but also enabling such talent to cross borders and work in those places where there is the highest chance of success or highest concentration of other talent, to enable network effects, which, of course, are proven to be behind innovation. I wanted, though, on that front, to briefly touch upon an area which I've described as seeking to effect attitudinal change. And I think of that as a form of infrastructural support for longevity biotech, because I think it can support the signaling of political and market demand that I mentioned earlier. And I think it also might help us as a field to work more closely with the aging well community, with which otherwise we have some differences potentially. But I think by focusing on one aspect of attitudes towards older aged, chronologically older people, I think we can achieve quite quite a bit politically and legally. So this is really the subject of age-related discrimination. There's been a realization, and therefore it has been made illegal in a very large number of countries to discriminate on the basis of age. That is a protected characteristic in the words used by European and UK legislation. But the problem here seems to be that it is not always and consistently taken seriously enough including by the courts. And so here for the first moment of emotion, this image is generated, of course, by a large language model and the prompt related to the case that I will tell you about. As mentioned, there is a broad prohibition in the European Union of such discrimination. There are, however, exceptions, and these concern, in the context of a directive against such discrimination in employment, they concern occupational requirements, but more broadly, there is the criterion of objective justification. So where there is a necessary reason why you must discriminate on the basis of age, that is something that may be permitted, provided that it's necessary but also proportionate. And so a case came to the Court of Justice of the European Union, and that's the highest court of that group of countries. And it concerned a pilot who was working for a subsidiary of Lufthansa, who was relieved of his duties, terminated when he turned 65. As I have already told you, there was clear prohibition and against such discrimination. The discrimination here had clearly happened purely on the basis of age. He had turned 65, he was terminated. But what could be proven by way of defense was the objective justification. So the dispute was whether there is this kind of objective justification. Unfortunately, that dispute didn't really happen. Quoted on this slide is the opinion of Advocate General Bobek. Advocate Generals in the European Union judicial framework express opinions that may or may not influence the court itself, but they're senior jurists. And that opinion was actually accepted by the court in this case. It was an opinion that seemed to focus on the fact that there must be some kind of objective justification, but the Advocate General didn't identify exactly what that justification was. Also, rather shockingly, the Advocate General did seem to endorse a approach of stereotyping, because he said that general rules, as their name indicates, are created by generalization, and that they're justified as long as it can be maintained that, in general, they properly apply in a reasonable majority of cases. And therefore, if you discriminated against older people and you had some good reason in a reasonable majority of cases, you would be fine to discriminate them in the minority of cases where you didn't have that reason. Mr. Fries, the pilot, had argued that there was no increased danger linked to the use of pilots aged 65 or over, and that's not been shown by any scientifically proven medical data. And the court, unfortunately, essentially swallowed the arguments of the Advocate General in their entirety, and even probably performed, with all due respect, less well than that, and simply made some sort of hand-waving gestures, as you will see in these quotations. So this was by way of showing you that, unfortunately, more work needs to be done on enforcing age discrimination legislation, and that might have a downstream impact on longevity. But turning now to the drug discovery process and what characterizes that process. And The overriding factor, perhaps, is a certain aversion to risk. And that's for good reasons. There were certain inflection points. I've given these in the case of the US, the first legislation in the US and correspondingly in Europe in the 1860s, but in the US in the beginning of the 20th century, concerned the purity and the quality of drugs. But in 1938, safety for the first time became an issue, and then by 1962, in a famous thalidomide scandal, of course, the question turned to putting the burden on the manufacturer of demonstrating efficacy and demonstrating safety. And that's what has given the very extensive powers to the FDA in the US and to other regulators elsewhere. That unfortunate set of events, and thalidomide was one of them, and prior to that it was the elixir, this is the trade name, elixir sulfonilamide, I believe, sulfonamide, sorry, which was an original antibiotic that had been mixed by a chemist with a manufacturer's chemist with a solvent, diethylene glycol, along with a raspberry flavor. So that, unfortunately, was poisonous, and this is what, in 1938, led to this legislation. What is regulated as a result of this aversion to risk is pretty much everything, starting from clinical research through to how you market and how you advertise. And again, I've mentioned risk is the biggest factor, but there are others that are occasionally cited. I won't have the time to cover those today. And this slightly disturbed and disturbing image, my apologies, I mentioned emotion, I didn't tell you that it may be mostly negative, was generated by a LLM when I typed in the simple prompt of consequences of litigation. And I don't know what kind of trauma this particular LLM has experienced, but this looks worrying, and I thought we should see it out of empathy. So the reason to mention the risks and consequences of litigation are that I think litigation has a place, and it just needs to be calibrated and considered carefully. And you will see in the context of risk and in the context of litigation that it played a role in the history of the right to try in the United States. And this is an example of a situation where an innovation, the right to try, has been successful, it appears, or at least moderately successful so far, in reversing a trend that had previously been very strong. So that strong trend, as you saw in the context also of anti-discrimination law, the reason why that pilot was fired and why the court didn't want to examine the true balance of scientific opinion was the waiving of the concept of risk. So as soon as the court knew that there were some experts that had somehow assessed risk, then the court was unwilling to examine the risk further. And that has been the history, that sort of deference to the power of expert opinion and the power of legislatures adopting approaches to expert opinion has been the trajectory of legislative history to date. But in the context of right to try, that changed. It appears as if it's changing a little bit. I will not discuss why the right to try might be relevant. It might not be super relevant, but it seems to me, I will only mention that it seems to me that it might be helpful either if there is a very prolonged period when we have evidence of efficacy, but that evidence is refused to be accepted by the largest regulators, the FDA, the EMA, and there is a long drawn-out process of acceptance there. Or it might be relevant in terms of the accumulation of evidence that would lead to the development of, for example, better biomarkers and surrogate endpoints. But so with the right to try, what is relevant in history is that there had been an attempt which reached the US Supreme Court. That's the Abigail Alliance case. And that concerned arguments that were founded on US constitutional law. Arguments were made, including that it engaged the right to self-defense, to be able to protect yourself from disease, essentially, by acquiring in interstate commerce goods, pharmaceutical goods, that were only approved at stage 1. They were investigational drugs approved only for that purpose. But a medical professional had somehow agreed, and there was a context of terminal illness or absence of other therapy as well. But in that attempt to obtain to get the US federal government to desist from enforcing the FDA regulations that would have enabled stopping that kind of substances to be obtained, that case failed. This was, though, in the mid to early, the case started in 2003 and ended in 2008. Since then, there's been quite a lot of policy activity. The Goldwater Institute, for example, had proposed a model act in that regard. And subsequently, of course, in 2023, as you will see, that resulted in the Montana statute being adopted, which removed the requirement for terminal illness and therefore enabled it in a much wider set of cases. But prior to that, there was another emotional case, and that was the case of Charlie Gard, which was in the UK High Court. I won't, unfortunately, have the time to cover it, but I'll be happy to tell you later about it. The current Montana legislation is now in place and appears that it can be made use of. I'm not qualified in Montana, so I cannot advise you on that. But it seems to me that on a quick reading, that there may be some gaps in the legislation that will make it slightly less useful. And that was perhaps the result of compromise. So, for example, disciplinary action is only prohibited where the sole reason for such disciplinary action against doctors or other healthcare professionals is that they did this prescription. But of course, that leaves out the possibility that that won't be the sole reason, that that will be one of several reasons. And that may have a dampening effect on physicians being interested in being involved. So I will, in the remaining time which I have, which is very limited at this point, I will also mention, as a final point, the interaction between FDA regulations or other regulations of investigational drug trials and specifically clinical indication as a concept and aging. And I will conclude with a few suggestions of other fields where we may wish to look into to see what interactions there may be. So what I can say in relation to clinical indications is that unlike the right to try, which is an area where you have had recent success in that regulatory innovation, with clinical indication, there seems to be, making aging a clinical indication seems to be an area where nobody is trying particularly hard. And my view is that it may be worth starting to try, because these discussions, again, absent any cataclysmic events, which rarely work in the direction of more openness. They did so in the case of COVID, but they generally tend to work, the knee-jerk reaction tends to be towards a more closed regulatory environment. So those discussions need to be started early. The message here is that there is no need to, and you will see that from this slide, if you can read it. My apologies if it's too small. In highlighted parts, you will see that this is in relation to China, to the US, and to the EU. None of these regulations, the definition of what is a medicinal product or a drug, require that, a disease can be, they don't require us to essentially define aging as a disease, because aging can be a clinical indication without being a disease. I think the important aspect of using aging as a clinical indication will be generating the kind of data on surrogate endpoints that regulators themselves will want and the field itself will want. And there will be future ways in which that will interact with applications. So very briefly, these are some suggestions as to other things that may be done. So developing, for example, playbooks that can be put in use in jurisdictions that wish to be innovative, where we seek to change the discussion before those jurisdictions have lined up fully or blindly to the position elsewhere, before they have raced along with everyone else to the top of the maximum possible regulation, for example. We may wish to educate regulators, and I've given here the example how in the US, the Chicago School of Economics conducted a summer initiative for many years where they took judges, treated them to a luxury experience. This was questionable with hindsight whether they should have, whether this was fair, but in any event, it seemed, some research shows that it influenced their opinion. And we should generally seek to investigate in detail various aspects, including, for example, specific tax incentives or interacting with bodies such as IRBs or RECs, ethics committees, essentially, in multiple jurisdictions, and informing them of the various views, ethical views on this. My apologies for overrunning. I am available by email, and my email is not legible here, but I am in the room if you wish to take it. And I will be very happy to engage with anyone who wishes to discuss these issues, and I think more research can be organized on them. Thank you very much.
Thank you, Kamen. Yeah, it's a bit of a change of pace, this session. Don't run away, we might have questions. Hey. It's a bit of a change of pace, this session, of course, but I think it's really important that those of us in the room who, spend all of our time thinking about biology should also be thinking about the broader context of how we are going to be, humanitarians first and foremost, how we're actually going to save lives with work we do. And, a reasonable understanding of the kind of thing that we just heard about is absolutely indispensable for that. Are there any questions? Here we go. Where's the microphone? Oh, one in the middle, first of all.
Yeah, thank you. I'm kind of surprised that you don't speak about what are for me the two main obstacles for research for longevity. Well, not only for longevity, but the first one is patents, and the second one is bureaucracy. So patents, it used to be in theory kind of a deal between an inventor and the society. The inventor has the right to use the patent, but has to make it public. And and the situation now is patents are secret and are making it impossible to advance in general, and especially for longevity research. And then there are all problems of very, very, very slow terms concerning all aspects related to authorizations, especially at the level of public organizations. So, especially, I would like to have your opinion about this. How bad is IP for your health?
May I answer your other question, though, first as well? I think in relation to bureaucracy and the speed, I think certainly there should be much more willingness to challenge delay, because such delay can, of course, have very real-world consequences. There are limited mechanisms because, for instance, if one sought to challenge through judicial review, that would require, perhaps in many of the cases, the only available route will be showing that such delay is so manifestly irrational that no rational regulator would have delayed it so much. There may be aspects of procedural impropriety which could be used to then challenge the delay. However, I think here we are again reverting to the combination of laying down new principles, new rules. For instance, requiring approval or an outcome subject to the lapse of a certain period of time, or requiring justification from a regulator if time has elapsed and there is no interim or final decision. Those should be explored. I'm not saying that they should be provided for necessarily. Do I have another 5 seconds?
You go on.
On IP, I think that's a very broad topic. I think you will see a lot of disagreement. Whether it is, I don't agree that patents are impossible to read, that they're not public. Obviously, they are public, they're very dense, it's difficult to understand them, but that's a separate problem. But I think, more generally, in terms of what's the most important problem or problems, there needs to be a lot of work done to rank these and to source other problems that no doubt I haven't thought about.
All right, thank you, Kamen.
Thank you.